But some patterns have emerged. The overwhelming sense one gets from these insider accounts is that decisions were not made, in fact, by this vast bureaucratic administrative structure with its expertise and its specialization, that it seems instead that many of these policies are the product of a nucleus of politically appointed advisors, that when called upon to interpret the law of war and to apply it to the global war on terror, rather than take advantage of this vast armada of military lawyers or these career civil servants that we find in the State Department that actually negotiated these treaties or were there when reservations or understandings were made to those treaties, the executive branch of the Bush administration did not resort to that expertise, but instead retreated to a core of politically appointed legal advisors. Now, politically appointed legal advisors that had impeccable legal credentials. You have to concede to these individuals that their credentials were first rate. However, that's not the point of the competency-based argument. The competency-based argument doesn't look at curricula vitae, it looks at experience, it looks at specialization. And so if the argument of the unitary executive theory is that these competency-based reasons should dictate a level of deference to legal decisions of the executive branch, don't we or shouldn't we demand that they be the product of that actual expertise? That, in fact, when decisions emanate from an Office of Legal Counsel within the Department of Justice, and from my readings, approximately 4 lawyers, can we really say that there's still a comparative advantage? Or did the executive branch surrender it? Are those 4 lawyers working in an office in the Office of Legal Counsel no different or perhaps even inferior to 9 lawyers with impeccable legal credentials that sit on the Supreme Court? There are a number of other questions I'd love to get to. I think I'll leave with this one. You know, can you still defend unitary executive theory? I was trying to do this last night, and I wondered about this. Well, couldn't a unitary executive theorist say, look, don't judge my theory on the Bush administration? That because they didn't resort to these competencies of the executive branch, that what we witnessed in the global war on terror and the decisions that were made in the global war on terror were not in fact unitary executive theory. Unitary executive theory would have directed the executive to defer to that competency, to listen to the Department of Defense and what it's telling you about the global war, about the Geneva Conventions, to listen to the Department of State and what it's telling you about the Torture Convention. So, you know, as much as perhaps old communists, I think there are still communists somewhere. You don't have to raise your hands if you're out there. But much as a communist would say, look, it's unfair to say that communism is a failed ideology because it was never really practiced the way it was intended to. Well, can we say that unitary executive theory was really practiced in the way it was intended to?
Thank you, Sean. Professor Banks.
Good morning. It's a pleasure to be here. It's a banner day in 2 ways. For me, it's my first trip to Topeka, and I want to thank Dean Romig and Professor Gehring and the staff of the Law Journal for organizing a very professional and top-notch conference. You've done a wonderful job. Second, it's a banner day because I find myself in a rare moment of agreeing in some respects with my colleague, Professor Turner. We've done this a number of times over the years, and I'm joking. We do share many things in common, and I think the panel has been terrific. I'll about clean up only in one respect. I'll try to pick on a few differences I have along the way and suggest a few questions perhaps and save some time then for discussion among us and with questions from the floor. I think that David Graham summed up as well as anyone could the problem before us. I think all of us in the room are lawyers, and I think the concept of proximate cause fits this situation to a T, and I won't say any more about that. And I also agree with his summation that the laws of war simply didn't fit the conflict that the Bush administration took us to. At the same time, I want to make a couple of observations about the present moment that cut in the other direction. It's very tempting, I think, here in November of 2008, at the very end of the Bush administration, and with the anticipation of a new way in a new administration, it's easy to point blame and to throw criticisms in the direction of those who've been leading the ship for the last 8 years. I think that what we should acknowledge, apart from the criticisms that have been made here today and those that I'm about to make, is that the questions that are before us are not easy. The fact that the law of war does not fit identifies a series of problems that we have to wrestle with, but doesn't lead us to solutions. The same way we might look at the United States Constitution and at the positive laws in national security law that purport to provide a framework for national security decision making. Those haven't fitted so well this set of circumstances either. And indeed, I think in the areas that are most often discussed today in the context of unitary executive discussions, detentions, warrantless surveillance, irregular or coercive interrogation, extraordinary rendition, in all of those areas, there are difficult questions and we haven't answered them very well. The unitary executive might have been sort of cheap wallpaper to get from point A to point B in some very unsatisfactory ways, in my view. But there's a tremendous amount of work for lawyers and others to do to move forward toward more constructive solutions.